NACDL is the association of the nation's criminal defense bar.
Okay, I'm going to get this out of the way. I am a white man, and my partner, when I was leaving to go to Los Angeles, and it had already been in the calendar that I was already coming to this event, I mentioned to him that I was going to be presenting, and he said, "What are you going to be presenting on?" And I said, Fourth and Fifth Amendment and racial issues regarding the Fourth and Fifth Amendment. He looked at me, he said, "Well, did the black guy cancel?" And that is indeed what happened. I have a lot of pressure on me because I was not the first choice. But I was coming, and I have been a board member for the past 3 years with the National Association of Criminal Defense Lawyers. And I am, I think, one of the quieter members of the board. And there's a reason for that. Because one of my best pals in NACDL is Nan Whitfield, who I wanted to congratulate for not cussing during her presentation, as she told us that she was going to do. And I spent a lot of time with Nan. I spent a lot of time with Ian Wallach, and we come to these seminars and we absorb the materials, and then we go out afterwards and we talk about what we learned. And invariably, I find myself out at dinner or a bar or something like that, and there's a discussion going on about what we learned during the day, and I will want to, from time to time, add my opinion on something. And Nan routinely, and I think Ian will agree with me on this, is I get this, no, you're a white man, no one cares what you have to say. So I go back to my drink, and I just continue to listen. But I am a lawyer from Chicago, and a criminal defense lawyer from Chicago, and I am blessed. Despite the fact that I am a white man, I came of age in a city that has had legendary African-American criminal defense attorneys, long before I ever became one. Our criminal courts building is named after George Layton, who was one of the most storied African-American criminal defense attorneys in this country. Before me, I tried cases with R. Eugene Pincham. I tried cases with George Howard. And I've tried cases with, in the newer generation, my very good friend Sam Adams. So where I come from, being an African-American criminal defense attorney is not rare. As a matter of fact, they're actually, in many cases, at the very top of our profession. So what I wanted to talk about a little bit was, and this is difficult because here I am in a room with the best criminal defense attorneys in the country, and I'm giving a lecture on constitutional law. And while I do that for students on a routine basis, I've never, ever given a talk to lawyers on con law. So it's difficult, but what I'm going to try to do in terms of the Fourth Amendment and the Fifth Amendment, I'm going to talk a little bit about data. Because as you're going to find out through the course of this presentation, the law sucks as it relates to race in the Constitution, particularly the Fourth and the Fifth Amendment. And for those of you who were here for Professor Carbato's presentation, I want to thank him. I know he had to leave, but his presentation this morning was fantastic. And one of the great takeaways that I got from Professor Carbato's presentation was this notion that the more contact we have with the police, the more bad things can happen. And when you target a particular group for policing, you are going to shape the narrative of how that group interacts with the criminal justice system. For instance, if you're going to target a particular group for traffic enforcement, for instance, you're going to have that particular group is going to have an increased likelihood of violence with the police, as Professor Carbato said. But you're also going to have an increased likelihood of wrongful arrests, wrongful prosecutions, undue financial hardships, and I'm going to talk a little bit more about that today, how the criminal justice system has been used to tax the poor and ethnic minorities in this country. As recently as 2 days ago, and I'll have the article up here, it was in the New York Times, an article to that effect. The more opportunities are going to have to be cited for suspended driver's licenses. And when you have a suspended driver's license, of course, you become subject to roving stops by the police. And of course, court appearances that maybe you can't make because of hardship, and then of course leads to arrest warrants, and then the cycle continues over and over again. So I want to start by talking about a little bit of data. And I'm going to start with this, because this is a case that I litigated recently, and this is a routine traffic stop on the south side of Chicago. I don't know if there's sound, or there should be sound on this. I'm assuming everybody has been subjected to a traffic stop in their lifetime for some kind of infraction. Did your traffic stop look like that traffic stop? And what do you think the driver of that vehicle was charged with? How about nothing? That is an Uber driver who is being pulled over because he picked up my client, who isn't seen on the video because of and was treated in the same way, and litigated this in front of a judge. And as we all know, the Constitution says there are 3 levels of police-citizen contact, right? Consensual encounters, a brief investigative detention, and of course, arrest that must be supported by probable cause. I advance a theory that this was an arrest. Who thinks that looks like an arrest? My judge, African-American judge, mind you, believed that this was just a brief investigative detention and denied the motion. The case is on appeal because there was a weapon recovered from a piece of luggage that was found in the back of that vehicle. But I use this as an example because, according to the Department of Justice, 42% of all citizen and police encounters start with traffic stops. And as practicing criminal defense attorneys, what does that mean for us? Is that roughly half of our cases all start with a traffic stop. And I think that's pretty consistent. And according to DOJ data, African Americans are twice as likely to be ticketed than whites, and that all racial minorities are 1.8 times more likely to be ticketed than white people. So knowing this information, and I don't think that this data is surprising to anyone in this room. I think it might be surprising to people who don't come to these types of events. And we look at some of the other data from this same DOJ study. After the traffic stop, the next phase we know is whether or not a search is conducted. And according to the Department of Justice, 2% of whites who are stopped for traffic are searched, 6% of blacks are searched, and 7% of Hispanic motorists are searched. But compare that with the North Carolina study from 2017, and the data that is there is, despite the fact that non-whites are searched at a much higher rate, it's actually white people that are searched that have the most higher incidence of contraband being recovered. And I throw this data at you because when we get to it, we're going to understand that the law isn't very good, but it's this type of data that we can use in our motion practice when we're trying to advance a theory or to undermine the credibility of officers that their bases for stopping our clients was not based upon race. 2016, a Cleveland study, and it's contained, the citations to all this is contained in the materials. Outside of Cleveland, they did a study in the Cleveland suburbs that black motorists accounted for 83% of the seatbelt violation citations, and that black motorists accounted for 88% of all driver's license offenses. And these two offenses, what the authors found was so significant about them was these were the type of offenses that were ex post facto justifications for the stop in the first place. These are the type of offenses that once you pull somebody over for a race-based reason and then you need to come up with a reason why you stopped this person, these are the type of ticketing that occurs. So the conclusion of this is that these racially motivated traffic enforcements shape the narrative. Police officers, it's found, have a natural bias to believe that if they run the license plates of non-whites, that they're going to get more hits for suspended driver's licenses and warrant checks. In 2014, there were 7.8 million active warrants in the United States, and the majority of these warrants were for unpaid fines and misdemeanor offenses. And if you listen to the professor's talk this morning in Ferguson, the cycle in Ferguson of the ticketing and into court and the warrants directed at non-white communities and poor communities is going on in all communities, and Ferguson is really just representative. A little bit here about the rolling checks, but the reality of it is that race-based enforcement is what creates the narrative of more suspended licenses, more warrants, more financial obligations that aren't being met. And so it brings me to this discussion and something that we're working on in Chicago, which is, I'll call it the Chicago Traffic Court Conundrum, which is in the city of Chicago, all moving violations in the city of Chicago require a court appearance. And I know that's different than a lot of different jurisdictions, but the reason for it, what some of the organizations who have fought against this and organizations that I've been a part of is mandatory court appearances allow for police officers to go to court, which leads to overtime pay so that the police unions want mandatory court appearances. The clerk's offices get fees for court appearances, and for that reason, the clerk's offices and the unions that support the clerk's offices also support the notion that mandatory court appearances should occur for all moving violations in the city of Chicago. So a lot of the judges, and one of the judges who's now a supervisor in traffic court, who is the former president of the Illinois Association of Criminal Defense Lawyers, is kind of pushing against this. If you look at this, and he does this in his opening statement to his courtroom every day, traffic court is exclusively downtown in the Civic Center. Within the city of Chicago, it's a very large geographic area. Parking downtown is about $35 to come to the Civic Center. The mandatory court cost for one moving violation, just for rolling a stop sign with court supervision, is $304. If you're making $10 or $12 an hour, that type of financial obligation, not to mention the day off work, already starts an individual in the hole. And of course, if you miss court, then you're required to either one, come in and move to vacate the warrant, which of course is another day off work, come downtown, stand in line, pay $85 to vacate that warrant, and if you don't, then you end up with a warrant in the system. And so what Professor Carbato showed us that was happening in Ferguson, this is happening in Chicago. I don't know what it is here in LA County, but $335 for running a stop sign, where if they had something in where someone could pay online, they could probably pay the minimum fine on it and never have to engage in the court costs, never have to involve themselves in the judicial system at all. I encourage everybody, the link to this is in the materials. This was in the New York Times just a couple of days ago, how cities make money by fining the poor. And there's some really good statistics in here. I don't know if you can read them, but I believe the statistics that I pulled from this was that experts assess that the amount of obligations for criminal court obligations that are on the poor communities in this country amounts in the tens of billions of dollars at this point in time. I won't spend a lot of time on the Ferguson, Missouri conclusions because Professor Carbato did that this morning, but the Department of Justice survey in Ferguson, Missouri concluded that 35% black drivers were 35% more likely than whites to be ticketed pursuant to a stop. Blacks were 93% more likely to be arrested, and that black drivers were 67% more likely than whites to have their vehicle searched once a stop had occurred. And that this racial disparity in Ferguson continued into the courts. Blacks were 67% of the population in Ferguson, but they were 74% of the municipal court population. And that within this court population, they were 81% of those who received summonses, 91% of the warrants, 95% of the arrestees on the docket, and that black defendants averaged 3.5 citations per appearance, which was 50% more than whites. And you know that in a traffic stop, there's a great deal of discretion that's given to police officers as to what they can write you for. We've had our clients who, you can be written for just one citation, you can be given a warning, or you can be certainly given multiple citations. Another area of data to look at is the racial inequality in marijuana arrests. Marijuana arrests account for half of all drug arrests in this country, and the data suggests that a significant racial bias in these arrests, despite the fact in 2013, the American Civil Liberties Union did a survey that marijuana use between whites and non-whites is pretty much equal. But if you look at what the arrests are, African Americans have been nearly 4 times more likely than whites to be arrested for marijuana possession between 2001 and 2010. According to Amnesty International, roughly 1/3 of the population could be targeted for racial profiling. And that racial profiling is defined as focusing on race, ethnicity, or national origin as a proxy for criminal behavior. So why does race-based policing continue? We have all of this data. All of us know that race-based policing occurs regularly, but why does it continue? And what I would suggest to all of you, is that for 4 decades, the United States Supreme Court has essentially sponsored race-based policing. And it started off really in 1975, United States versus Brignoni-Ponce, which, if you're familiar with this case, it was a stop about 65 miles from the Mexico-California border, and that the officers in that case pulled over the defendant, an individual of Puerto Rican descent, because they appeared to be Mexican. And the court suppressed the evidence in that case, but created some terrible, terrible law. Because what the Supreme Court said in that case was that Mexican appearance alone would not justify the traffic stop. However, it did allow that someone's ethnic appearance could be one of the factors, along with a variety of other factors. And in this opinion, for instance, officers can rely on, and I highlighted in red the ones that are incredibly subjective and can be anything but race neutral. For instance, characteristics of the area in which the law enforcement officer encounters the vehicle, which means the neighborhood that you are in. Previous experience with alien traffic, which means that the police officer's subjective experience dealing with alien traffickers can be factored in along with Mexican appearance. Aspects of the vehicle, including certain station wagons, heavily loaded in appearance, or an extraordinarily large number of people in the vehicle. And again, very subjective and anything but race neutral. And then, of course, my favorite, the Supreme Court said, well, characteristic appearances of persons who live in Mexico, such as the individual's dress or haircut. A year after the Brignoni-Ponce decision, the Supreme Court actually went so far in security checkpoint case to say actually that Mexican appearance alone is sufficient. And it is sufficient to police officers or border patrol officers at the border. If someone just apparently looks to be Mexican, they can divert them for secondary screening. And the Supreme Court of the United States versus Martinez-Fuerte, the rationale on that was, well, this is just a minimal Fourth Amendment intrusion, and therefore we will allow for Mexican appearance alone to be sufficient. Now, one of the things that's important to remember, and I know this is a criminal defense organization, but in deportation proceedings, the Supreme Court has held that those are civil in nature and that traditional Fourth Amendment exclusionary rule analysis does not apply. So if you have an INS versus Lopez-Mendoza, however, there is some good news. The Ninth Circuit has held in Gonzalez-Rivera that racial oppression is one of the most serious threats to our notion of fundamental fairness, and courts generally consider reliance on the use of race or ethnicity as a shorthand for likely illegal conduct to be repugnant in any circumstance, which is great language, because in deportation proceedings, according to the Supreme Court, in order for the exclusionary rule to apply, that the litigant in those cases or lawyer must prove that there is either widespread race-based enforcement or that the individual violation was particularly egregious. There's been some pretty good dissent out there on the Fourth Amendment and race as it relates to constitutional rights at the border. In the United States versus Zapata Ibarra, Fifth Circuit 2000, Judge Weiner's dissent I thought was particularly salient, where he writes that history is likely to judge the judiciary's evisceration of the Fourth Amendment in the vicinity of the Mexican border as yet another jurisprudential nadir, joining Korematsu, Dred Scott, and even Plessy on the list of the most shameful failures to discharge our duty of defending constitutional civil liberties against the popular hue and cry that would have us abridge them. And I think that's a particularly important quote considering what the current culture is in this country in terms of immigration and the border. Perhaps I think the most significant case that sponsored race-based policing is Whren versus United States, which everybody's very familiar with. The facts of Whren, two black men in the District of Columbia who were pulled over for spending too much time at a stop sign. They were pulled over by narcotics officers, and upon approaching the vehicle after the traffic stop, the officers in that case found, I think, the passenger of the vehicle to be in possession of crack cocaine, and the prosecution went from there. The defendants in that case challenged the legality of the stop and seizure in that case, and the Supreme Court held, because up until that time, many of us knew that we could successfully bring protectual challenges under the Fourth Amendment. And Whren did away with protectual challenges, an opinion written by Justice Scalia. It was held that the officer's subjective intention for pulling over the individuals in this case was completely irrelevant for Fourth Amendment purposes, and that any type of remedy that was being sought should be brought under the Equal Protection Clause, which I hope we all know that the Equal Protection Clause has no remedy for criminal defendants because there is no exclusionary rule. And of course, when I'm doing, in that case, the defendants in Whren all received sentences in excess of 10 years. When I'm doing 10 years in prison, bringing an EP challenge in civil court is of little value to me. But the interesting thing about Whren is that a couple years later, a year after Whren, Justice Kennedy's dissent, and Whren was a unanimous opinion by the Supreme Court. Justice Kennedy walked back a little bit from Whren in Maryland versus Wilson, which is the case that authorized police officers to order passengers out of a vehicle during a routine traffic stop. And Justice Kennedy's dissent in that case was the practical effect of our holding in Whren, of course, is to allow the police to stop vehicles in almost countless circumstances. When Whren is coupled with today's holding, the court puts tens of millions of passengers at risk to arbitrary control by the police. If the command to exit were to become commonplace, the Constitution would be diminished in a most public way. Which is interesting because it is a year after the Whren opinion, but Justice Kennedy is already walking back. Other cases that came after Whren is Devenpeck versus Alford, 2004 case. It's a civil case, and in that case, up into the Devenpeck, the Supreme Court had held that, or at least suggested federal courts did, that the initial basis for a stop, what you're ultimately arrested for, needed to be, quote, closely related. In the Devenpeck, the court held that the closely related doctrine was no longer valid, and as long as there was any reason, any type of probable cause could be found, then what the officer's subjective intent was for pulling over or stopping the individual was of no consequence. In Herring versus United States, a fascinating case here, 2009. In this case, in the Herring case, the court held that a criminal defendant or a suspect in this case who was found to have a warrant out for their arrest is searched and found to be in possession of contraband, but that there really never was a warrant for their arrest. It was a clerical error, had no Fourth Amendment remedy because the exclusionary rule would have, according to the court, the exclusionary rule would have no effect because negligent record keeping was not flagrant enough to trigger the exclusionary rule. The defendant in that case must show that the record keeping that left my warrant in the system 3 months after I quashed the warrant was left there deliberately. And finally, just a couple of years ago, probably the worst of the bunch is Utah versus Strife. It's an opinion written by Justice Thomas. And in Utah versus Strife, the court came to a new holding in there, is that if an individual is curbed or stopped, citizen is, for no reason at all, no constitutional basis whatsoever, and that a subsequent check of that individual for a warrant pops up, and then of course a search incident to that arrest is sufficiently attenuates the initial illegality, and there is no remedy for our clients under those circumstances. And I think the most important thing about the Strife case is to read Justice Sotomayor's dissent in that case. In part of it, she's joined by Justice Ginsburg and Justice Kagan, but I want to go through some parts of that dissent because I believe as practitioners, Justice Sotomayor's dissent in this case must be our battle cry as we approach pretrial litigation in these cases. I don't want to read it all, it's up there, but I'll read the second part where she was writing alone. She says, by legitimizing the conduct that produces this double consciousness, this case tells everyone, white and black, guilty and innocent, that an officer can verify your legal status at any time. It says that your body is subject to invasion while courts excuse the violation of your rights. It implies that you are not a citizen of a democracy, but the subject of a carceral state just waiting to be cataloged. So, putting it all together, 40 years of Supreme Court jurisprudence. Brignoni-Ponce, looking Mexican is good enough. Whren, Doesn't matter whether the cops are racist. And as a side note to Whren, if you know the backstory of it, both of the officers who arrested the defendants in Whren were later charged criminally in those cases for criminal activity on their part. Both of them were stripped from the DC Police Department, but it doesn't matter according to Justice Scalia and the majority in that case. In Devenpeck, it doesn't matter what the officer's subjective intentions were, as long as there was some probable cause. We can find some somewhere. In Herring, oh, too bad, we picked you up for a warrant, and the warrant really wasn't a warrant. You don't have a remedy. And of course, Utah versus Strife says the police can stop us for any reason, and if a warrant pops up in the system, that's going to sufficiently attenuate the initial illegal contact. And I would suggest to all of this, particularly in light of what the Supreme Court is looking like today, that the exclusionary rule is in jeopardy. And this line of cases and following what's possible to come in the next several years is that the exclusionary rule is in jeopardy. And as a practicing criminal defense attorney, other than the presumption of innocence and the right to counsel, I firmly believe that the exclusionary rule is our best weapon that we have, and we need to guard it zealously. There was a spark in the Second Circuit, and this is contained in your materials, but in the Second Circuit, they did, contrary to Whren and contrary to Utah versus Strife, found that officers stopping someone just based upon race-based was sufficient for a suppression. And good quote in there from United States versus Hussein: we recognize that it is the totality of the facts and unfolding events in this matter, but we are hard-pressed to see how a driver in a high-crime area in the Bronx, or anywhere for that matter, moving his right arm and hand around the center console to retrieve a smartphone can reasonably suggest that danger lurks any more than a suburban father or mother reaching for a smartphone from their center console after a traffic stop to call a spouse or a relative to be considered dangerous. So there are some sparks on the appellate level, but there are not many of them. So knowing all of this, the reality is, what I said in the very beginning, is that the exclusionary rule is really not available in racial profiling cases, and that the law kind of stinks. So what are we supposed to do about it? Well, we still file our motions. And in filing our motions, we have to start mining data. And more police departments are keeping data on traffic stops, police, citizen, Terry stops in contact, keeping the demographics of the individuals stopped. They're keeping information in terms of when a search ensues after a routine stop, and we have to use our subpoena power to get that information. If you're familiar with anything regarding the efforts that are made in predictive policing, a lot of that data is being held now by police departments for their own purposes, and we need to reach out and try to get this. Now, police departments are very resistant to give us this information, but we have to be persistent about it. The Illinois State Police, for instance, for almost a decade now, has been keeping data on traffic stops, when searches occur, when the canine units are brought there. And we need to, I suggest, we need to bring this data into our motion practice. We need to investigate our officers. Some of you heard, I think at the last meeting we were at, that Barry Scheck and some others in New York are starting a database for police officers, where individual police officers for wrong conduct, that there's going to be a database in New York that all defense attorneys are going to have available to them to be able to investigate the individual officers. I have taken to social media. We have a Facebook page for Cook County criminal defense attorneys. And when there's an issue with a certain police officer, we try to share police reports with each other. We try to share information with one another, and using the listservs to learn information about these particular police officers and their habits. And a lot of things that we get from pretrial motions are, particularly when officers' motivations are race-based, can we set the table up for trial? Can we lock them in? Can we ferret out this information so that come trial time, the police officers' motivations for treating our clients in a particular way because of their perceived race or ethnicity, can we interject that into the trial and perhaps be successful? I want to talk about a couple of cases that I've been involved with. Okay, just a couple minutes left. This case right here, prosecutors dismissed 50 of an officer's cases. Officer John Haleas was a Chicago police officer. He was statewide the largest DUI writer 3 years in a row. He wrote between 360 and 500 DUI citations per year. He had been honored by Mothers Against Drunk Driving. He had been honored by police associations. And John Haleas looked like Elmer Fudd. He was a very mild-mannered guy, short, kind of dumpy. He worked in a car by himself, and it became apparent to a lot of defense attorneys that John Haleas it was not possible for him to conduct a DUI investigation as a DUI investigation should occur in the time periods that was allowed. So we started digging into John Haleas. And what we found was that he worked midnights, and he worked on the northwest side of Chicago in a predominantly Mexican-American community. And what he would do was he would sit outside bars that catered predominantly to working class Mexican-Americans, a lot of blue-collar guys worked in the trades, and he just would pull cars over. He would take, if the driver smelled of alcohol, he just saw him leave the tavern, he would take them to the police station, put them on the breathalyzer. If they blew under the legal limit, he released them with a seatbelt violation. If they blew over the legal limit, he would write the field sobriety test up in a particular manner. And if they refused the breathalyzer, then he wrote the field sobriety test up in a very damaging way. And it was apparent to all of, Officer Haleas, who was writing between 300 and 500 DUI citations, and of course mandatory court appearances for all Chicago police officers, he would work midnights, he would get off, go to the Daily Civic Center, he would sit there all day for the morning and afternoon call, and he was making about $175,000 a year as a Chicago police officer with all the overtime that he was billing in for these DUI citations. So we began bringing motions, and we began to show that one, everyone he was arresting, based on the names in his police reports, all appeared to be Latino. Two, that the timetables for unrelated DUI arrests weren't matching up. There was no way he could have gone through the field sobriety test, done the 20-minute observation, read the warnings to motorists, and do everything that was required within this time period. And we began trying to put that forward into our motions against John Haleas. And of course, denied. State objection, not relevant, denied. And of course, John Haleas is at the Daily Center all the time in front of these traffic court judges. They all know him. He's a mild-mannered guy. They're not going to let us attack his, impugn his credibility. But we kept trying. And a group of defense attorneys got together, and we began sharing information on him, and we began pushing the needle and pushing the needle and pushing the needle with these cases. And ultimately what happened was Haleas ends up on a ride-along with two young assistant state's attorneys. And am I running out of time? Okay. With two young assistant state's attorneys, and he does with these two young prosecutors in the back of his car what we had said he was doing all along. He was just picking people up, pulling them out of the car, takes them, puts them on the breathalyzer, and then writes up the field sobriety test later on. Well, they reported this to their supervisors. Their supervisors had already had this information that attorneys like myself and Charlie Beach had already submitted to the supervisors at traffic. And ultimately, John Haleas, they dismissed all of his pending DUI cases, and he was indicted for perjury and obstruction of justice. And the reason I bring this up is not to say, oh, a great attorney did this. No, but it's because attorneys, defense attorneys, we bang our heads against the wall. We lose, we lose, we lose. But sometimes in the end, if we keep banging our head against the wall long enough, we win. And I'm going to finish off with this one. Do I have time, Mike? Okay. This is another case. All right, I'm going to go through this real briefly, and a lot of this is in the materials, and there's a ton of stuff on here. If you're really bored, you can go through the discs. There's a ton more stuff on here. But Highland Park, Illinois. Highland Park, Illinois just recently became sort of a model city for eradicating racial profiling and racial sensitivity among their police department. If you don't know where Highland Park, Illinois is, it is on the north shore of Chicago, very wealthy suburb, huge police department for a place where nothing happens. But Highland Park got a real black eye, and it got a black eye back in 2010 when defense attorneys, again, defense attorneys in Lake County and Cook County, Illinois, were constantly filing motions why their clients of color were being pulled over on US 41. And lawyers began, after we're losing these motions, they began to mine the data. And they got some radio transmissions from the police officers. And here's what the radio transmissions said regarding a pullover of a car of African-American students at Lake Forest College who were pulled over and rousted by the Highland Park police. It was heard on the radio traffic with the Highland Park, "I'm stopping a load of coal heading up 41. And that began with Capitol Hill hearings with police officers who came forward who said the following. Officer DeRose, that another officer explained to me that if a Mexican is wearing a hat, there's a 50% chance he is drunk, and a 100% chance if he's wearing a cowboy hat. Another officer told me on many occasions that he would make traffic stops and figure out the probable cause later. The racial profiling allegations are contained in a amended version of the original lawsuit. That the police officers in Highland Park were ordered to change their crime statistics to eradicate the race-based traffic stops, and that the officers were instructed by their supervisors to target racial minorities coming north on 41 and to keep them out of the central business district and the beaches in Highland Park. And then 2018, Highland Park Police Department becomes the first in the state to embrace principles aimed at building mutual trust between that police department and communities of color. And I bring this up again because while it was a settlement between the city of Highland Park and the ACLU, who recovered this information that started this ball rolling? It was criminal defense attorneys who were filing motions, who were doing their due diligence, who were subpoenaing the radio traffic, who were ferreting out that terrible racist things that cops, sometimes we can catch them saying on the radio. And because of that, Highland Park's become a model in 2018 through the ACLU for racial sensitivity training with their police department. So I think I'm out of time, and there's a lot more there if you guys want to look at it. So thanks very much.